Fundamentally, the antitrust laws are about harm to competition in markets. So we define the market as our unit of analysis, where that harm or benefit to the marketplace might occur. The credit card industry operates in what we call a two-sided market. Companies like MasterCard, Visa, and American Express balance two sides in the marketplace. On the one side, stores or merchants that accept cards and allow consumers to use them at the point of sale. And on the other side, consumers are attracted by benefits that cardholders offer, frequent flyer miles and other amenities. Whereas stores are attracted by the prospect of increased sales by consumers who wish to use that card inside the merchant's marketplace. In two-sided markets, market definition presents a fundamental difficulty. There are more than one market or more than one group of consumers affected. Whether antitrust law would treat two-sided or multi-sided markets differently than single-sided markets was really what was at stake in Ohio versus American Express. What was at the heart of this particular litigation is a contractual provision that American Express requires merchants to agree to. Occasionally, merchants would steer customers at the point of sale towards using MasterCard or Visa rather than American Express so they could use lower merchant fees. A steering arrangement, a contractual provision imposed by American Express on retailers, prohibited merchants from doing so. American Express's business model was charge higher merchant fees, prohibit steering to its competitors at the point of sale, but to use those higher fees to fund its benefits to consumers. Because of the steering provisions, American Express was able to increase output over time, become a more effective competitor against MasterCard and Visa. The tricky question in front of the court was whether American Express's steering provisions that clearly resulted in slightly higher prices for merchants at the point of sale were part of the normal competitive process or were anti-competitive. Justice Thomas' opinion focused on the economics of two-sided markets and how to distinguish them from the normal single-sided markets that antitrust is normally concerned with. Justice Thomas' opinion identified that the card networks at work here, American Express, were transactional platforms. And the way they competed was a little bit different than we think about the steel industry or the automobile industry or supermarkets or other markets that we commonly see at issue in antitrust cases. Here, firms compete by bringing together two sides of disparate markets that have interdependent demand, cardholders and merchants. A rule that harmed to any group of consumers on any side of a platform would be sufficient to declare a practice unlawful, Justice Thomas reasoned, would result in a rule in which all sorts of pro-competitive activity would be chilled. The antitrust laws would be doing the opposite of what they were designed to do. In order to avoid that result, Justice Thomas and the majority set forth a relatively straightforward rule. It is not a special rule for platforms. It is bringing in line antitrust rules for platforms with traditional treatment. Plaintiffs have the same burden, that is, to satisfy the prima facie burden, a plaintiff must show harm to the overall competitive process. Justice Breyer authored the dissent in the opinion, joined by Justices Sotomayor, Kagan, and Ginsburg. Justice Breyer's dissent held that the appropriate way to handle multi-sided markets under Section 1 of the Sherman Act would be to allow the plaintiff to prevail wherever it could show harm to one group of consumers. In this case, Justice Breyer would have concluded that because merchants pay higher merchant fees when they use the American Express network, as a result of the steering fees, that would be sufficient for the plaintiff's burden to be dispelled. The majority decision makes clear that the antitrust framework for Section 1 that applies to traditional markets is flexible enough to reach transactional platforms, credit card networks and ride-sharing apps being two particularly good examples. The decision leaves open whether that same approach will be applied to non-transactional platforms that have advertisers on one side and users on another and are missing that component where each side can be held together through a common transaction. that remains to be seen, likely in future litigation.